Hey guys, and welcome to today's video. Today we have a court Karen who refuses to accept responsibility for her actions and a no-nonsense judge that's not going to let her get away with it. So let's begin.
So these are the people versus J.C. Owens. Can I get your appearance?
Yes, thank you, Judge. Andrew Mickus on behalf of Ms. Owens, P 76268. Ms. Owens would waive any objections to appearing via video today as well, Your Honor.
Okay. All right, did you speak with Mr. Zick this morning?
I did, yes, Your Honor. I think we've reached a mutually agreeable resolution to the matter. Ms. Owens is going to be entering a plea of guilty to one of the matters, and the court will be dismissing, and Mr. Zick will be dismissing the other matter. We didn't get specifics as to case numbers, but they are essentially identical. She would agree to any restitution amount. He did not have a figure before him. I estimate that that figure is going to be 0 because I believe all of the items were recovered in both cases at the time of the arrest. So I do anticipate that. But in the chance that I'm wrong and there is restitution, she is able to pay that today.
You know, it amazes me how thieves always seem to have the money for the items they were stealing, but only after they've been caught.
Are you pleading guilty of your own free will?
Yes, ma'am.
And Mr. Zick, I see you're back on this. Is there a preference for the people on which matter she should plea on?
No
I'm
preference.
just gonna plead. Okay, all right. So ma'am, back on, how do you plead to the charge of larceny?
Guilty.
Were you in the city of Taylor on January 31st of 2023?
Yes, ma'am.
And when you were in the city, did you go to Walmart?
I did, Your Honor.
And when you were at Walmart, ma'am, did you take some merchandise that wasn't yours?
Yes, sir.
What's wrong? Having trouble admitting out loud that you're an antisocial piece of shit? You know you could have avoided all this if you'd have just paid for your items to begin with.
Your Honor, I think she's stalling just because there was an attempt to do so, but because she didn't leave with the items. I did discuss with her the legal nuances between those and that there really isn't one. So, JC, do you understand the question? She's asking if you attempted to take any items for sale.
Attempted, yeah.
All right. Where was she stopped? Parking lot or as she was exiting the building?
Before exiting the building.
Or as you walking out of the building, Miss Owens?
I was going towards the door.
I think she had just left the self-checkout area and was heading towards the door when store security stopped her and initiated.
And were there items that you didn't pay for when you went through self-checkout?
I mean, I don't know how to answer that. Honestly, Your Honor, I left the cart. I walked away from it. I don't know how to. And then the other one was,
Hang on, JC.
Wait, so Miss Owens, did you put property in your cart or in a bag that you didn't intend on paying for?
I mean, no, but.
Sounds like a not guilty plea to me, and just because you left the items behind on your way out the door probably because you knew you were caught doesn't mean that you weren't attempting to steal them, and just as your lawyer said, in the eyes of the law there is no distinction between actually leaving the building with the items and attempting to leave the building with the items but failing to do so.
All right,
yes,
I can't accept the plea, then we'll get a jury trial date.
Your Honor, I'm guilty.
Your Honor,
no, you're not guilty. Miss Owens, you've been through this before. You've got a ton of larceny convictions, right? This isn't your first rodeo. And ma'am, you're not required to enter a plea of guilty. But if you think you're going to sit here, I'm talking. If you think you're going to sit here and tell me that you didn't do anything wrong and think I'm going to accept your plea, you're sadly mistaken. I'm happy to have a jury trial. I like nothing more than a jury trial. You either want to accept a plea or you don't, and you're either going to be honest to this court and accept responsibility or you're not. It's that simple. And if you cannot lay a factual basis for what you did that makes you guilty of this charge, I will see you on your trial date. Are we clear, Miss Owens?
Yes, Your Honor.
Ism. Judge Shackelford does not have time for around defendants when there is a simple find-out solution to all these problems. It's called a jury trial. Now let's see if Karen can get it right the second time and accept responsibility for antisocial behavior.
So what do you think you did, Miss Owens, that makes you guilty of larceny?
Your Honor, the first offense, I didn't scan an item, and honestly, it wasn't to steal the item. I tried to pay for the item.
All right, so that's a not guilty plea. So, okay, we're gonna just go ahead and set these both for
But the
jury
second
trial.
one, I did intend to. So, I mean, yes, I'm guilty on the second. Yes.
You accidentally didn't scan
No.
$250 worth of items?
No, I didn't say accidentally. There was a computer or something
No,
wrong
on
with
the
that scanner.
first case, the allegation is that you stole 8 items worth $250. And you're telling me that was an accident?
Your Honor, I'm guilty.
That's not how that works. You don't get to just say I'm guilty. You actually have to lay down the factual basis behind your guilt. This is to ensure that the right person is convicted for the crime that was committed and b. to establish a clear record of facts to prevent you from coming back later and saying that you are actually innocent. If you don't like how the process works, then stop stealing.
We're going to jury trial.
Your
I'll
Honor,
set a jury trial date and we'll see you on that date.
Your Honor, if I may have an opportunity briefly in a breakout room with my
No,
client.
I've had enough of your client, quite frankly, and the games she likes to play. She's lucky I didn't revoke her bond the first time, and now she wants to play with whether or not she's responsible of this or not. And no, I'm not comfortable taking a plea. She's made it clear she didn't do anything. We're all set. You'll get your jury trial date in the mail. We're all set, ma'am. I'll see you on your jury trial date. Thank you.
Ma'am, please.
You'll get notice in the mail.
I didn't.
Bye, have a great time.
Okay, so this isn't the actual end of the video, as the judge is about to explain to the lawyer exactly why she can't take her plea and gives him one opportunity to talk the entitlement out of his client.
Mr. Mikos, I'm sorry, I'm not tolerating your client and her nonsense. We'll set it for jury trial. If you talk her into taking a plea that she can reasonably put on the record without being full of nonsense, I'll consider it. But for now, we're going to trial.
A few moments later.
All right, we're back on the record. This is the People versus J.C. Owens.
Yes, thank you again, Judge Andrew Mikos, P76268 on behalf of Ms. Owens.
Ms. Owens, tell me your name.
J.C. Owens.
Ms. Owens, did we go over your constitutional rights a minute ago? Do you remember those rights?
Yes, ma'am.
Knowing all of that, how do you plead the larceny?
I plead guilty, Your Honor.
Back on January 31st of 2023, Ms. Owens, were you in the city of Taylor?
Yes, Your Honor.
Did you go to Walmart?
Yes, Your Honor.
I want you to tell me what you did that makes you guilty of larceny.
I intended to steal items, Your Honor, without paying for them.
What items?
I think, I honestly, I don't remember what items exactly, Your Honor. I think they were just normal, like condoms and stuff. Toiletries, yeah.
You stole $250 worth of condoms, toiletries?
Why?
Did you take them with the intent to deprive that Walmart of their property?
Yes, Your Honor.
And did you take those items and put them in a bag without scanning them at self-checkout?
Yes, Your Honor.
Oh, that was amazing. Well done. That's the best turd I've ever seen. Congratulations. You're special.
Are you satisfied, counsel?
I am satisfied, yes, Your Honor.
All right. I'm going to accept the plea as knowing and voluntarily given. The case ending in 230962. That case will be dismissed per the plea.
You see, Karen, it wasn't that hard to take responsibility for your actions now, was it?
Meet with the probation department for a pre-sentence investigation. You're going to get notice of that in the mail.
Okay.
And you're going to meet with them and I'm sorry, Mr. Mikos?
No, go ahead, Judge. I'm sorry.
Yeah, I think we need an evaluation. So you're gonna meet with the probation department, Miss Owens, and they're gonna contact you for a pre-sentence interview. After that interview, we'll meet again for sentencing. Are you still on felony probation?
JC, are you still on probation with Judge Matthews? Yes.
Yeah.
Okay. All right. Well, I'm assuming a lot of things will likely run concurrent, but I want my probation department to at least look at it. And Mr. Mikos, I can't give you a sentencing date because I don't know how backed up they are on their PSIs.
I understand.
So it'll be a Wednesday and we'll get it out to you in the mail as soon as they meet with her.
Okay, we're probably talking a few weeks out.
At least, I think generally 3 to 4.
Okay.
And bond conditions will just continue until that time.
Sounds good. Thank you, Judge, and thank you for your patience today.
All right, I'll see everyone at sentencing. We're all set.
Alright guys, that's the end of the video. It turns out that she could chew down those paint chips stuck in her throat just enough to admit that she's a thieving window licker. So if you liked the video, leave a like. If you disliked it, leave a dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content.